Indian Evidence Act had 167 sections. Now, under BSA, there are 170 sections. Like BNS, as I said, there are certain terms which have been deleted from the BSA also. Like Parliament of United Kingdom, Provincial Act, Crown's Representative, Dominion, London Gazette, Lahore Jury, etc. As also Vakil, Pleader, Barrister. These words have been deleted. Earlier, Indian Evidence Act was not applicable to the Army Act, the Naval Discipline Act, or the Indian Navy Discipline Act, the Air Force Act. They were excluded. But the BSA has been applicable to these acts also. Now, from the section 1, which mentioned short title application and commencement, the word India has been deleted. Just now I have mentioned about the abatement from outside India to have been made an offense. So to make the Evidence Act presently the Shakshya Adhiniyam boundaryless, the word India has been deleted so that acts, or rather offences done beyond the territory of India can also be brought within the purview of BSA. Now, the definition of documents, which was earlier in section 3 of the Indian Evidence Act, has been defined in section 2(1)(d) of the BSA, which says documents means any matter expressed or described or otherwise recorded. So these words, or otherwise recorded, were not there in the Indian Evidence Act. Upon any substance by means of letters, figures or marks, or any other means, or by more than one of those means intended to be used, or which may be used for the purpose of recording that matter, and includes electronic and digital records. So these words and includes electronic and digital words have been incorporated. Now, video recordings on mobile phones may also qualify as documentary evidence. Electronic or digital form of official gazette is also admissible as evidence. This has been defined under section 31 of the BSA. Use of law books in digital electronic form is also admissible under section 32 of the BSA. Now, certain definitions under every code or every act you would find in section 2. Earlier that was not there in the Evidence Act. Section 3 had defined the terms. Now in the BSA also, section 2 gives for the definition of certain words, and the words which have not been defined in section 2 of the BSA, it finds its definition either in BNS or BNSS or the Information Technology Act of 2000. The words which are used in the parlance of BNS, BNSS and evidence, Shakshya Adhiniyam in totality, if certain words are not there in section 2, their usage, their definition are found either in BNS, BNSS or the Information Technology Act of 2000. Yet again, this definition of document, including electronic evidence and digital records, have come up observing the direction of Supreme Court in, you can write this down, P. Gopal Krishnan alias Dilip versus State of Kerala and others, that is 2019 SCC Online SC 1532. In paragraph 26 of this judgment, the Supreme Court observed it was well established by the Apex Court that the electronic record produced for the inspection of the court is documentary evidence under Section 3 of 1872 Act. So in this particular decision, Supreme Court stated that electronic record produced for the inspection of court is documentary evidence. That was with regard to Section 3 of Indian Evidence Act 1872. Now, in BSA, within the definition of documents, under Section 2(1)(d), the inclusion of electronic and digital records have been incorporated to define documents. Similarly, Section 2(1)(e) of evidence of BSA mentioned all statements, including statements given electronically, which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, and such statements are called oral evidence. All documents, including electronic or digital records, produced for the inspection of the court, and such documents are called documentary evidence. So electronic and digital records find its place not only in the documentary evidence, but also as far as the oral evidence is concerned. For example, you videograph an instance, or the CCTV camera records a particular instance which you are aware of, or a comment on part of an individual is known to you. You adduce before the court the same statement with regard to the videography. That is acceptable as an oral evidence. Further, the videographed portion marked as exhibit to be a documentary evidence. So why is this addition? For obtaining a technology neutral approach, so that it can be both in the form of an oral evidence as well as documentary evidence. Now somebody said that we need to prove the facts, right? One of you said? Who said? You said? You said. So you need to prove the facts. So what kind of facts would be there? I mean, the facts would be in two forms. One is the fact in issue, and the other one is the relevant fact. Facts means what? Anything, state of things or relation of things capable of being perceived by the senses. Secondly, any mental condition of which any person is conscious. You can write down another citation, that is Ira Bhadrappa versus State of Karnataka, AIR 1983 SC 446, which defines fact to be a concrete or something material to which the information directly relates. issues are the principal matters in dispute or relevant facts which are evidentiary or which directly by inference prove or disprove the facts in issue. Now, earlier, the Evidence Act only mentioned facts in issue. But now under the BSA, it involves not only facts in issue, but also the relevant facts. That means the facts which are directly involved, directly perceived, as well as something ancillary to it, which can also have a repercussion with regard to the circumstances. According to the word relevant, it means any two facts to which it is applied are so related that according to the common course of events, one either taken by itself or in connection with some other facts proves or renders probable the past, present or future existence or non-existence of the other. Can you cite an example? Anybody can cite an example with regard to relevant fact? Can anybody tell me an example of relevant fact? One is fact in issue and the other one is relevant fact. Suppose a person caused death of another person. What can be the probable conditions? One, intended to cause death. One, caused death through accident. The other possibility can also be through sudden and grave provocation. Causing death is the facts in issue. Right? What are the ancillary facts? Whether the person had intention, whether the person had knowledge, whether it was accidental, whether it was under sudden provocation or instigation. So, all these facts taken into totality would result in res gesta, which is a concept under section 6 of the Indian Evidence Act, and now it has found its place in section 4 of the BSA. Now yet again it follows from the decision of Supreme Court in State of Maharashtra versus Kamal Ahmed, Muhammad Vakil, Ansari and others, 2013 12 SCC 17, in which the Supreme Court observed it was submitted that only such a fact as is so connected to a fact in issue so as to be treated as a part of it would constitute res gesta and would not be excludable by the rule of hearsay. The above proposition of law has been laid down by the apex court and the same followed by the other courts. We have to see whether there is an interval or time lag between the act committed by the accused and the time of statement given to the witnesses, and was it a long one so as to give time or opportunity for fabrication. So somebody can say that the act was committed under sudden provocation. So one has to inspect the situation, whether there was a sudden provocation or not, whether it was directly committed, whether there was an intention, there was a conspiracy, there was premeditation, everything to be taken in its entirety. Earlier, under the Indian Evidence Act, caused by inducement, threat or promise, confession to a police officer, confession in the custody either of the accused or by the victim or by the witness was inadmissible in evidence. Now section 24, 28 and 29, which specified these kinds of confession under the Indian Evidence Act, have been clubbed together under section 22 of the Evidence Act, along with incorporation of the word called coercion. Earlier it was only restricted to inducement, threat or promise. Now it also includes the word coercion. Again, it falls from the decision of Supreme Court in the same case that I have cited, State of Maharashtra versus Kamal Ahmed, Muhammad Wakil Ansari and others. It says, admissions and confessions, though generally considered hearsay, are exceptions due to their inherent reliability as declaration against one's interest, making them relevant and likely true. Their admissibility in evidence is based on their potential to infer truth independent of communication to others. However, section 25 and 26 of the Evidence Act excludes confessions made to the police officer or in police custody, aligning with section 24's requirement that the confession must be voluntary and free from coercion. But the statute said threat, inducement and promise. Supreme Court in this particular decision introduced the word coercion, which has now been incorporated in section 22, which clubs all these three cases: confession before a police officer, confession in the custody, and confession under inducement, threat and promise in only one section, that is section 22, including the word coercion. This exclusion ensures that such confessions which may be influenced by coercion, threat or promises are not admissible in evidence. Right? Now, there has been another exception to section 24. Earlier, it so happened that in a case, there had been, say for example, 6 accused persons. The police could apprehend 3 of them and could not apprehend the other 3. So the trial would proceed against the apprehended accused, 3 in number, and the court would state in the order sheet, file for present. File for present means that the case record and the trial will not proceed with regard to the other 3 accused persons who had not been apprehended by the police. Say for example, 10 years afterwards, police could arrest the other 3 accused, bring them to court, and the trial would start de novo. So you can understand the exercise given into it. There will be a new set of trial. The witnesses might not be there. Some of the witnesses might die. Most of them can be won over. So there could have been or would have been multiplicity of judgments, multiplicity of opinions. So to eradicate that possibility, in section 356 of the BNSS, certain processes have been prescribed. First, if the police fails to arrest, warrant will be issued. If that warrant could not be executed, there will be a proclamation. And if that process gets exhausted under 356 of the BNSS, then there will be a trial in absentia. There will be a joint trial so that the time is saved. Thereafter, there will be a joint trial in absentia, as if those persons who could not be brought to trial at that point of time was present. So this is a new introduction to section 24 of the BSA as an exception. With the introduction of electronic and digital form of evidence, certain statements before the court becomes relevant and they are admissible. I'll just read them out. One, the official gazette in digital and electronic form. Use of law books in digital and electronic form is admissible. Earlier, only the judgment of a court was relevant. Now the judgment of tribunal, the decree or order of a tribunal is also relevant along with that of a court. It comes under section 35 of the BSA. It says a final judgment, order or decree of tribunal is relevant. Previously, the relevance was only restricted to final judgment, decree or order of the court, of a competent court. In section 39.1 and 39.2, opinion of experts are considered to be admissible. Earlier it was restricted only to foreign law, science or art, etc. Now it has incorporated the phrase any other field. Now any other field expands the horizon to infinity. Any other field can include each and every aspect where the court considers that expert's opinion is important. It also includes the opinion of the examiner of electronic evidence. So these two sections have been clubbed under section 39 of the BSA, which was earlier section 45 and 45A of the Indian Evidence Act. There are certain sections like 52 where court would take judicial notice of certain facts, deleting the use and jurisdiction which were earlier mentioned, as I said, Parliament of the United Kingdom, local and personal laws, articles of war for the Indian Army, Navy, Air Force, etc., etc. These are no longer required with the changed status. Now, under section 57, primary evidence now includes digital electronic record created or stored simultaneously or sequentially in multiple files. Each file is a primary evidence. Suppose in your laptop, you save a file on the desktop or in the documents, or you prepare a separate file. So, same document saved in different places sequentially, each of them become a primary evidence. You transfer in your mail a document which is there in your mail to another, what do you call that, HTTP URL to another place. So when you are sending it from your mail ID to somebody else, or for that purpose to another mail ID of yours, each one of them becomes the primary evidence. Similarly, if you record a CCTV footage or a recording or a videography and then you store it somewhere, either you can in multiple desktops or in your mobile. So in each of those documents, the electronically stored documents become the primary evidence, each one of them. Electronic record produced from the proper custody if not disputed. Video recording simultaneously stored, broadcasted and transmitted to another device. Each of its stored recording is primary evidence. Electronic record automatically stored in a multiple storage space in a computer resource. Each automated storage is primary evidence. As I said, maybe in the draft or in the document or the desktop it can be, or that bin that you call, there also it can be stored. Now the ambit of secondary evidence has been enlarged to oral evidence, written admissions and evidence provided by a person who is skilled in examining certain documents, which being technical or voluminous cannot be conveniently examined. Suppose you have land records for years together and it has to be brought before the court. It is voluminous. But through the process of digitization, it has been digitally stored. So reference to that can also be given through secondary evidence and it will be considered. Section 61, it provides for the effect, the legal effect of digital and electronic evidence. Now you produce hard copy of a certain document, the certified copy, right? So that is taken to be the proof of any fact, for example a registered deed, and it is marked exhibit in a court. Similarly, if you produce an electronic record of that deed itself, it will also be proved. So there is no longer any distinction between a paper record and an electronic or a digital record. So it has the same legal effect, that of a paper record as well as an electronic record. Now, how to prove this electronic records? What is the point of admissibility? That is mentioned in section 63 of the BSA. It says electronic records copied in semiconductor memory shall be considered in addition to optical or magnetic media. These are all technical terms. Electronic records produced by any communication device or otherwise stored, recorded or copied in any electronic form. That can be a DVR, flash drive, CD, DVD, server, cloud, etc. and not produced by a computer only, as was the case under the Indian Evidence Act. Computers or communication devices can be in standalone mode, on a computer system, on a computer network, or on a computer resource, enabling information creation or providing information processing or storage or through an intermediary. Now, court is not a technical body. The judge who is there has no technical expertise. Somebody can come and produce anything. So this was stored in the cloud, this was stored in particular computer. Will the court take cognizance of it? Can it be admissible? Can it be admissible? No. Then how can it now come under the definition of electronic evidence? It has become a source of primary evidence. It has also at times become the source of secondary evidence. And it has found its place in the definition of documents under section 2, subsection 1D of the BSA, as also section 2(1)(e) of the BSA. Now, how it can be made admissible? So the BSA has provided a schedule. The schedule consists of 2 certificates. One is Part A certificate and the other one is Part B certificate. Now Part A certificate is granted by the person who has the custody of the device. That particular person certifies that this electronic evidence or this electronic or digital information was stored in this particular device. So Part A is signed or it's endorsed by the person who has the custody of the device. And Part B certificate is endorsed by a technical expert in electronics, giving the hashtag value and the other technicalities with regard to that storage media, stating thereby that the information has been loaded in this particular medium and had been a part of that particular device. So, what is the Part A certificate? It is to be signed by the person in charge of the computer or the communication device, and Part B is the certificate which mandates the signature of an expert whose endorsement serves as proof of any statements contained therein. Within the certificate. Once the certificate is signed, it serves as an evidence in a court of law. So we have section 61 newly incorporated, we have section 63 providing for the admissibility of any electronic device. Then with section 74, 77, there are earlier these definitions of public documents, private documents. They have been incorporated in section 74 and 77, deleting those words, as I had said, United Kingdom, Lahore, jury, etc., which have become archaic and no longer significant. So these expressions like crown representatives, etc., have been deleted. Now, as you know, that certain documents and certain situations are presumed to be true, right, which comes under presumptions. Now, presumptions as to gazettes, newspapers and other documents, presumptions as to gazettes in electronic or digital documents, presumptions as to documents of 30 years old, presumption as to electronic records 5 years old. These are those documents which now have also introduced the words electronic or digital form. So once they are stored in electronic or digital forms, how will the court presume that they are to be admissible? If the presenter can prove that these documents were in proper legal custody and their origin or source was legitimate, then these documents will be taken to be admissible by the court. So this has been a new introduction, that if a document is 30 years of age, or for that matter 5 years of age, in the official gazettes, etc., and if they are produced electronically or digitally, the presenter has to prove that they had a legitimate origin and they were kept under proper custody. Then again it has to follow the same process of obtaining the certificates under section 63 of the BSA. Earlier under section 116, the concept of estoppel. Now this is the only section mainly pertaining to the civil laws. It said that no tenant of immovable property or person claiming through such tenant shall during the continuance of the tenancy be permitted to deny that the landlord of such tenant had at the beginning of the tenancy a title to such immovable property. Now section 122 of the BSA has mentioned not only at the beginning of such tenancy and continuance of the tenancy, but also any time thereafter. Once the tenant has accepted the the right, title and interest of the landlord in a property, is precluded to deny the same at the beginning of the tenancy, during the subsistence of the tenancy, and any time thereafter. Suppose A was inducted as a tenant under the landlord B. B sold out the property and to C. So A now becomes a tenant under C. Under no circumstances can the tenant deny the title of B under whom he was the initial tenant. This is just an example, but once you have approbated, you can subsequently never reprobate. Once you have accepted the authority of a person to be your landlord, you can under no circumstances deny that that particular person did not have any title to have become the landlord as far as the tenant is concerned. So in section 122 of the BSA, these words have been introduced, or any time thereafter. Now under section 124 of the BSA, instead of lunatic, the word unsound mind has been used. In section 138, in the definition of accomplice, it says, an accomplice shall be a competent witness against an accused person, and a conviction is not illegal if it proceeds upon the corroborated testimony of an accomplice. This removes the inconsistency with illustration B in section 114 of the Indian Evidence Act, which is presently section 119 of the BSA. Now this again follows from the decision of Supreme Court in one case called Soma Sundaran versus the state 2027 SCC 722. You can write it 2027 SCC 722. What does it say? Section 133 of the Evidence Act declares an accomplice. And what is an accomplice, or who is an accomplice? One who knowingly has assisted another person in commission of an offense is called an accomplice. Section 133 of the Evidence Act declares an accomplice as a competent witness, allowing convictions based on their uncorroborated testimony. So earlier it was uncorroborated, now it has become corroborated. Section 114 illustration B permits courts to presume an accomplice is unworthy of credit unless corroborated in material particulars. judicial interpretations emphasize the need for corroboration due to the inherent unreliability of accomplice testimony. A person who has knowingly assisted another person cannot be trusted entirely. Key rulings such as Sarwan Singh versus State of Punjab and Harun Haji Abdullah versus State of Maharashtra stress that corroboration must implicate the accused in the crime. Sheshanna Bhumanna Yadav versus State of Maharashtra and K. Hashim versus State of Tamil Nadu confirm that corroboration can be circumstantial but must connect the accused with the crime. This cautious approach ensures reliability and prevent false convictions. One can very easily accuse somebody else out of grudge, out of revenge. This particular case has established a precedent and consequently resulted in a noteworthy alteration to the provisions outlined in section 133 of the Indian Evidence Act, as manifested in the subsequent section 138 of the BSA, thereby resolving the contradiction of section 133 and section 114 of the Indian Evidence Act. So earlier, the uncorroborated testimony could be accepted, which again was in conflict with section 114 of the Indian Evidence Act, but now under section 138, the statement of the accomplice must be corroborative in nature for the purpose of its admissibility. And then under section 165 of the Indian Evidence Act, 162 of the Indian Evidence Act, the production of certain documents with regard to communication between the ministers and the President of India was not allowed. Now, it falls from Article 74 of Clause 2 of the Constitution. Though earlier in the BSA, the privileged communications have not been properly defined, but Article 74(2) of the Constitution, it stated that the communication between the minister and the President of India cannot be called by any court for the purpose of recording any evidence, etc. So that has now found its statutory recognition in section 165 of the Indian Evidence Act, which says that courts are not allowed to demand production of any communication between ministers and President of India, and there is also a case law to that effect, S.R. Bommai versus Union of India, 1994 SCC, page 3. Earlier in 166 of the Indian Evidence Act, power of jury and assessors to put questions were there, which has now been completely deleted. And section 170 of the Indian Evidence Act now says that prior to 1st of July 2024, the provisions of Indian Evidence Act will apply, and thereafter from 1st of July 2024 onwards, the provisions under BSA will apply, and the earlier act, that is the Indian Evidence Act, gets repealed. So this again precisely gives you the details of the changes that the BSA has brought in. I think I have not missed any section. Yes, sir? So you asked them to meet after lunch.